I think there's a generally kind of accepted and acted upon business practice, by folks putting together these CCS projects to negotiate and secure agreements from the surface owner for pore space rights. Now, there's a business consideration as to whether or not you want to also secure the mineral interest rights because of condemning their ability or impeding their future ability to develop their mineral interest. That's a separate business measure that we see people taking. But is there any indication that we're going to get some definitive, black and white rules on that, or some clarification on that? Is that a legislative matter that the legislature is going to have to act on, or?
It could come. I think eventually the legislature will step in. It could be the courts first, and it's later kind of codified. That's what's happened in some other states. The general consensus is there's no reason to believe Texas wouldn't follow what's become known as the American rule, which is that the surface owner owns the pore space. But yes, you're right. I mean, there's other implications about, once you start injecting, carbon dioxide into the ground, if that could, impair other types of operations such as oil and gas development. And so you're probably going to want to either secure rights from the mineral owners, get a subsurface use agreement, something like that. They're going to want to know that everything's been properly cased, and there's a number of sort of practical considerations there. I think where possible, to the extent it is still possible in Texas, if you can find an unsevered mineral estate, maybe an area where there's not a ton of production, then, that's going to be your ideal location. But you're probably going to be dealing with severed owners, and you're probably going to want to get them and as many people to sign off as you can on these projects.
Yeah, it's what we've seen is you want to minimize your risk, and really that's the measures that are being taken at this point. Satisfy yourself and get to a point where you're comfortable enough.
Well, and I think the best way you can do that is to hire a world-class broker like Dudley to go out and, make sure you've got the right owners and you're getting the right parties to sign on.
That's cool. Well, man, if you think back through this year, like this year is the year of the pore space, right? You got all these CCS projects that have kind of been coming into various levels of maturity. We're starting to see some of these projects actually, have a line of sight on happening. We've had the whole lithium thing. We've had cactus water. I think everybody's beat up cactus water enough. I think we all understand the implications of that. But lithium has been the big thing, that's talked about, especially in Texas. Obviously, Arkansas, it's a world-class reservoir. You see a lot of publicity and a lot of press over the last 3 months for whatever reason. It's like there's been a big marketing push. I'm seeing articles all in my feed about, the lithium deposit in the Smackover Formation. And we're seeing, kind of to your same point with who owns the pore space for injecting CCS. The question in Texas is who owns the right to the lithium extracted from brine? What's the latest there? Are we getting a better line of sight on what the rules of the game are going to be in Texas? So talk about Arkansas, a whole different animal.
Right. Well, that's right. And you're exactly right. And I think that one of the issues is that, lithium prospectors in Texas want to look at Arkansas and say, well, look, they've figured it out. Can't we just apply that here? A lot like CCUS, there's just still a lot of question marks. I think what makes it, in a lot of ways, a little bit simpler in Arkansas is that they decided many years ago, back in the 50s, that brine is a mineral itself. And this had to do with bromine extraction and some other chemicals that they were chasing in the brine at that point. Texas has never adopted that type of philosophy here. We don't have, they call it the Strohacker doctrine there. We don't have anything like Strohacker here. We do know that groundwater generally belongs to the surface owner. So that much is settled here in Texas. But what's a little less clear is who owns the constituent elements suspended in the brine, such as lithium. And what generally happens in Texas is you have to adjudicate every single element individually. That hasn't happened yet. So, Brent, to your point, either the legislature is going to have to step in or the courts are going to have to make a decision. The closest thing we have is uranium case law that has said that uranium suspended in brine belongs to the mineral estate. Uranium is an element. There's reason to believe that lithium, being another kind of element on the periodic table, is eventually going to be adjudicated a mineral. And if that is the case, then you're probably looking at dealing with both the surface owner, who might own the brine or the groundwater, and the mineral owner, who may own the lithium itself. So, it could end up being an interesting trying to secure the rights to the lithium, and then some kind of surface use agreement or lease or something like that with the surface owner, to allow you to produce their groundwater, extract the lithium, and then re-inject it.
Yeah.
So
is there a distinction, either by case law or by, legislature, that distinguishes between traditional groundwater and produced brine through various, deep drilling operations? Is there any that well-defined distinction there?
So, I think there is a distinction, and that's really what's at the heart of the Cactus water case. Is, there was a 2019 statute that transferred title to the produced water to the operator or the lessee. But the philosophy back then was that this was a nuisance, byproduct, and it was essentially forcing them to take it and deal with it and take title to it. And now suddenly you're seeing this produced water increase in value, not only for, fracking operations and recycling, but for potentially lithium as well. So, it's kind of up in the air right now. Under Texas law as it currently stands, a lessee would kind of take title to that produced water. However, you're seeing a lot of landowner groups coming forward, making constitutional arguments, making a lot of arguments that this really should belong to the surface owner. And again, nobody cared about it until it suddenly had value. They were more than happy to have, to wash their hands of it, so to speak. But now suddenly there's some money there. They're making a lot of constitutional arguments. So we'll see what the Texas Supreme Court decides to do with that one as well.
Yeah, I know there's been a tremendous amount of leasing activity. We're very much in the cutthroat time of land acquisition. Obviously we have big players out there. Everybody knows who they are. You got your Saltworks, you've got ExxonMobil, you've got Equinor's jumped into the mix.
Yep.
And then you've got a whole slew of, folks out there, trying to grab acreage in hopes that they can flip, right? You're starting to see some of the unethical things happening. You're starting to see people represent themselves to be working on behalf of these big companies just so they can get acreage. Are there any cases, and this is all very relevant to us right now, some of the work that we're doing, very competitive environments. How can a mineral owner, for instance, and this is a little bit off topic, but it's relevant. How can a mineral owner who's been misrepresented, the facts of who a landman or a broker that's dealing with them or trying to negotiate a brine lease with them, what's their recourse if they're misrepresented? In other words, if a landman or someone's trying to secure a lease from them and says that they're working on behalf of a company, and turns out they're not. Does a landowner have any recourse, mineral owner have any recourse there?
I think you'd probably be looking at common law fraud and misrepresentation, things in that nature, possibly some equitable arguments to have the lease set aside, and again, it would be kind of a fraudulent type activity, very similar to how, in my opinion, you started to see these leases that were being taken a few years ago that were actually mineral conveyances, and companies were going out and saying, hey, we're going to lease your minerals, but it was really and truly a conveyance in perpetuity of their mineral interest. Texas stepped in legislatively and put an end to that pretty quickly. You have to have certain statutory language now in those situations. But so to answer your question, there's not a lot of recourse other than taking them to court to have the lease or the conveyance set aside. One other thing to watch out for is you were certainly seeing lithium conveyances and lithium leases in the guise of oil and gas leases. It'll it'll call itself an oil and gas lease. It'll have a royalty that looks a lot like a traditional oil and gas royalty, but buried somewhere down in the fine print, you're going to be relinquishing your rights to brine, lithium, produced water. It's going to be at a very low royalty, maybe 1/32, 1/10 down to 1/32, something like that. And you're probably going to see a longer primary term than is customary. You're not going to see 3 years. You're going to see more like 10 years or even 20 years on some of these. So those are kind of red flags that somebody's probably trying to secure lithium rights in your area and sort of doing it under the pretense of oil and gas
lease.